The Florida Supreme Court has given us jury instructions, and those jury instructions lay out the elements for each particular offense. In order to have a crime, each one of those elements has to be proven beyond a reasonable doubt. In criminal law, I always start backwards and work forwards. And you determine what is the weakest element, and that's the element that you're going to attack. It's attention to the details that can make or break a case. I've had a case where there was an alleged battery in a small opening of a stairwell. The client's alleged to have swung a bat at someone, and you're in a 2-foot hallway. By reenacting it, it was physically impossible to swing a baseball bat in that narrow of a stairwell. When I can, I always walk through it with my client. We go out and we reenact. I get a perspective of where my client's coming from, and I also get an outside perspective of having read the police reports and read all the statements prior to going out there to determine, is it feasible? But if you never went out there and you just read it on a police report, you wouldn't know if that hallway was 2 foot or 10 foot. You don't ever want to be surprised in a trial. If the piece of paper says there's 5 pills of evidence, there needs to be 5 pills of evidence. You have to go down to the crime lab. You have to go down and look and see what evidence they have against your client. I've had cases where I've gone to the crime lab and they say there's marijuana in the crime lab, and that was the reason for the arrest. And you go down and there's no evidence of any marijuana. The officer wasn't truthful in the stop, and we could ultimately get that case thrown out. So by going down to the crime lab and looking to see what evidence, it's crucial. You have to go down and see what's not in evidence. Sometimes you find more evidence that isn't listed on any paper that could, be beneficial to your side of the story. Officers aren't perfect, they make mistakes. I like to give them the benefit of the doubt, but a lot of times when an officer is questioning you or gathering evidence, it's not for your benefit, it's for the state of Florida. Once someone's been arrested, there's a delay between the filing of formal charges and the actual arrest. Once you are arrested, you want a lawyer who can make contact with the prosecutor's office. The reason you make contact is twofold. A, we could present enough evidence or information to allow the prosecuting authority to make a decision not to file charges and dismiss the case right off the bat. Which is a great result. The second option or reason to make contact with the state attorney is to minimize your client's risk. There's certain nuances in crimes to where one could be punishable by 30 years in prison, the other one could be punishable by 15, or even a third one could be punishable by 5. By getting in early and presenting your side of the case, you could ultimately reduce your client's exposure from 30 to 15. One of the things that I try and do is I make contact early on with the state attorneys to try and reduce my client's exposure. Automatically right there, that's a win. Instead of playing at a table where someone could lose 30 years of their life, we have it down to 5 or even a misdemeanor.